crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome into the attorneys. Thank you so much for joining us tonight. Our topic of conversation is industrial accidents. So a really interesting subject matter and one that affects a lot of folks and a lot of ground to cover here. I have a great guest to lead us through that conversation. But first, I want to give you some ground rules in case you are new with our show here. We would love to have you join the conversation. All throughout the show tonight, you'll see ways at the bottom of the screen where you can call, text, email, get in touch with us. We'd love to hear from you. So if you have a question and want to get that to us, would love to hear it. Also, Hollis Wright does a unique thing. They make attorneys available each and every Sunday night during the airing of the show. So right now, attorneys from Hollis Wright are standing by live to speak with you. That's a free, off-air, confidential conversation, and it's an opportunity that is yours for the taking. So if you want to take advantage of that, at any point through the show tonight, you can give them a call, 844-LAW-TALK. That's the magic number. You know that all the time. That gets you right to the firm. 844-LAW-TALK is the number. Locally in Birmingham, 205-324-3600, or you can text that number, 205-670-1949. So plenty of opportunities, again, to speak with them attorneys from Hollis Wright who are standing by. Leading our conversation tonight, a partner at the firm, Carter Clay. Good to see you, sir.
Good to see you, David. I hope you're doing well.
Doing well. You look like you look good. Well, I think you've lost a little weight, Carter.
Well, thank you. I appreciate that. I guess everybody has. Hopefully, you should have time to be exercising, but I've heard some people go in the opposite direction. They've just been at home and eating.
Yeah, I think there's a Corona 15, right? That's what I'm hearing.
That could be. So we're going to be talking about industrial accidents tonight. You've just got me again. Obviously, we're still in the midst of this COVID-19 pandemic, so we thought that it would be best just not to have guests back on the shows. I'm really looking forward. That's one of the great things about the show is having guests who are lawyers in the community that can talk about a whole host of legal topics, but we just thought it would be best to continue on this course of just having lawyers from our firm be on here. Hopefully, in the not too distant future, we'll be able to bring our guest lawyers back on the show.
How has the pandemic, the virus, affected the daily going-ons at the firm?
So really in two ways, I would say. Number one, I think with almost every personal injury law firm out there, everybody has realized a reduction in the number of leads or intakes that they have gotten over the last few months. Obviously, with everybody under quarantine, a lot of people getting laid off, unfortunately, losing their job. There's just not as much economic activity. There's just not as much activity in general with people riding around and working. And so I guess one of the positive results of COVID-19, although they are very few, one is that there are less people getting injured and killed on the roadways out there or in job-related or industrial-related type settings. So that's one thing that I think everybody has realized. The other way that it's really changed is that we're using more technology. Zoom video, WebEx, hearings are now taking place by video, and on some levels, that is a positive change for us because we have a very statewide practice in terms of representing people who have sustained personal injuries. And it really, in some respects, it makes it more efficient. But the big issue that law firms are confronting right now is you cannot try a case by video. And so right now they're not having any in-person jury trials, obviously trying to protect the general public from coming in and having to serve on jury duty. And so right now we're not having any jury trials, so that negatively impacts the practice that we have in personal injury practices in general.
You got it. I mean, in business, every business has to pivot right now, and I was interested as to kind of how you guys were pivoting. So our subject matter tonight, industrial accidents. Help us kind of from a launching off point, what specifically, what would fall under that designation as an industrial accident?
Well, so in a normal year, and I stress normal because we're not in a normal year.
This is anything but.
In general, there are about 3 million workers out there that will be injured or killed in some way, shape, or form, some minor injuries, some major injuries. But in a typical year, we would see that across the country. Obviously, we expect that number to be meaningfully down for 2020 given the COVID-19 pandemic. But generally what we're talking about when we're talking about industrial accidents is we're talking about individuals almost exclusively people that are on the job in some capacity,
Okay.
being injured in either an industrial plant type accident, a construction type environment, a chemical or assembly line plant environment, or maybe even some type of mining accident. Obviously, there's a lot of mining activities here in the northern part of Alabama, and so that is something that is significant to a lot of viewers. But generally, we're talking about somebody injured or killed in those types of situations.
Okay. So these are really what these accidents are kind of different than the personal accident, like a car accident. It's more job site.
It is. That would be probably the biggest distinction that I would make is that a lot of the types of cases that we handle at our firm, motor vehicle accident cases, medical malpractice cases, premises liability or slip and fall type cases, a lot of cases that we handle are not related to somebody's employment.
Right.
Okay. These types of cases are almost exclusively related to somebody's employment, typically where an employee is working on a construction site or in an industrial plant, chemical plant, a mining environment. And what's important about that, and I know we're going to get into this later, is that there are really two potential claims that you need to look at when you're injured or you have a family member that is killed in that type of situation.
Right. All right. So talk to us about the idea of a co-employee case. What is that, and why does that matter to us?
All right. So a lot of times when you get into these types of situations, the accident that caused an injury or death may be the result of some type of misconduct by a co-employee. Okay, a fellow worker. That's just a different way to describe a fellow worker. Typically, though, you cannot bring a claim against a co-employee for a simple mistake or simple negligence. Okay? And let me give you an example.
Please, yeah.
Co-employee is driving another co-employee in a work-related vehicle.
Right.
All right? Co-employee who's driving reaches down to pick up his bottled water, and he mistakenly runs a red light and gets into a collision with another vehicle. It's clearly the fault of the co-employee. Okay, he was distracted or he looked down. So the passenger employee is injured, and he's got two potential claims. He's got a workers' comp claim because he's injured on the job, but he may also say, well, wait, I want to bring a claim against my co-employee. Okay, in that type of situation, you could not bring a claim against a co-employee for simple negligence. Okay, for a simple mistake. And I know we're about to go into the break, so I kind of tease a little bit. When we come back, there are some exceptions to that rule, which we need to talk about.
All right, we will get into the exceptions to the rule when we come back as we head to break. A reminder, Hollis Wright does a great job on social media, Facebook, Twitter, Instagram, YouTube. Just search the term Hollis Wright. You'll find them there. Just a really great job they do of keeping us informed and educated on legal matters. So stay tuned. Stick around. We've got more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas: bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, That's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys.
Welcome back into the attorneys. Thank you so much for joining us. Before we get back to our conversation with Carter about industrial accidents, a reminder, if you want to take advantage of the opportunity to speak with the attorneys from Hollis, Wright, 844 Law Talk, locally in Birmingham, 205-324-3600, or for all you texters, 205-670-1949. When we went to break, Carter, we were talking about co-employee cases, and you said there are some exceptions to the rule, and let's jump into those.
Yeah, so let's change the fact pattern that I gave to the viewers before we went to break involving the automobile accident where you've got one co-employee driving and another co-employee in the passenger seat. Let's add a fact.
Okay.
Let's say that the driver was under the influence of drugs or had consumed a 6-pack or a 12-pack of beer prior to getting behind the wheel of the vehicle.
Okay.
All right. That is potentially an exception to the rule. Obviously, if you are doing something more egregiously than just looking down, picking up your bottled water, the law is going to say, well, hey, that's probably an exception, and we're going to allow the injured party to make a viable legal claim against the driver because of the egregious nature of his conduct. Intoxication is one. Another example might be intentional conduct. Okay, one co-employee intentionally wants to hurt another co-employee for one reason or another. I mean, I don't want to take this to R-rated level, but maybe one's having an extramarital affair or something, or maybe the other co-employee got a promotion that other individual thought he should have gotten.
You've been watching too much Netflix.
Well,
on
you
this
say that,
coronavirus.
Dave. You say that, David. However, we've seen this over 20 years. We've seen this type of conduct occur in a job setting where, I mean, have you ever heard of one person shooting another person for being involved with, a spouse or a girlfriend? I mean, these things happen in the real world. People get promoted and other people get upset. So intentional conduct would be another example, okay?
Okay.
One other exception would be removal of a manufacturer-supplied safety device. Let's say, for instance, they're in an industrial setting and they're working on some major piece of equipment or a product, and the manufacturer provides a safety feature or some type of safety device that is intended to prevent injury and accident. Okay? Let's say the safety device breaks and the co-employee removes it, but then doesn't replace the safety device. Or perhaps they order it and then it sits on the shelf for 2 or 3 months and they don't install it in a timely manner, and somebody gets hurt as a result of the removal or failure to replace a safety device. Okay? Those are the types of exceptions that we're talking about. I had a case one time many years ago involving that very situation, involving an industrial piece of equipment where you've got to bring these two big pieces together. They've kind of got to mate together. You got like a male shaft and a female area, and they're supposed to mate together. It's a hexagonal shape steel shaft. Well, the workers were having problems getting these things to match up or mate. The manufacturer provided a device, which was a safety device because it was dangerous for them to be manipulating this equipment, and they sent it to the employer. Well, the co-employee who was responsible for the installation let it sit on the shelf for several months and didn't install it. My client gets his hand smashed during the mating process or the matching up process, and he had a hand amputation. And so we brought a claim against the co-employee for failing to install that type of safety device. So those are generally some of the exceptions that we see.
Wow. So talk to me about third-party liability. What is that and how does that work relative to this?
Typically what we see in these types of situations when we're talking about third-party liability involves a product liability case. Okay? And I'll give you, the best way I can describe this is giving you an example or illustrate a case that I had many, many years ago involving an individual, a worker at a manufactured housing plant in Mobile. And he was working this huge industrial saw that had multiple 18-inch steel diameter saw blades in this machine that would create the wooden trusses for the roofing structure of these manufactured houses. And as he's working the machine, the steel diameter saw blade broke off ricocheted around in the machine, came out of the machine, and hit my client in the leg. He's lucky he did not have an above-the-knee amputation, but it basically shattered his femur, and he had to have major surgeries to repair it, but he was never able to work again because he was a laborer, and that was really his only chance. He had a limited education, and so he really needed to be a laborer, but this injury prevented him from ever doing that work again. What we found out during the course of our investigation is that the manufacturer had drilled the countersink holes where the bolts go through to attach it to the machine. They were oversized. And the holes were oversized, and what that resulted in is excessive vibration on the heads of the bolts. And over a period of time, that excessive vibration caused the bolt heads to shear off and fail, which ultimately allowed the steel diameter, 18-inch steel diameter saw blade to come off, and the incident happened. We filed a lawsuit against the manufacturer of the saw blade, claiming a product defect in that particular product. So that's what we're talking about when we're talking about third party. We're talking about a party other than the employer of the employee.
That's a pretty good investigative work there.
Well,
to figure that out.
Well, we got some help from the employer because the employer immediately called in engineers from the manufacturer because they were concerned about the entire product, and the engineer from the product manufacturer came down there and did the assessment, and he documented that the countersink holes were oversized. So when we got that document, what we kind of call a hot document in our industry, it really helped out.
Yeah, that quite the assist there. All right, so so U.S. law requires that employers follow specific regulations so that workers are not injured due to occupational toxins. All right, so what are some types of occupational toxins?
Well, we've all heard about asbestos. Yeah. That would probably be the biggest one 30, 40 years ago, and those cases have been settled, but there's a huge trust fund out there to pay off of.
No one's using
claims.
asbestos anymore, are they?
Well, nobody's using it, but it's still in certain buildings and in certain environments. But the real issue is people that were exposed to it many years ago, they're just now getting the injuries that were caused by asbestos because there's a long latency period before the injury arises. And so that's one example. You've got benzene and PCBs. We don't handle a lot of those types of cases at our firm, but there are firms out there that exclusively handle environmental exposure type cases like that.
Right. Some of the others, chromium, PCBs, you hear a lot about PCBs.
That's right.
For sure. What steps should I make sure are taken after being injured in an industrial accident? Let's take a break. I'll tell you what. Let's pick up with that one when we come back. All right. So if someone's been injured in an industrial accident, what are the steps that need to be taken?
Yeah, because that's a very important question. So we don't want to just run through that before the break.
All right. So this is our final break of the evening. Stay tuned. We've got more of the attorneys coming right up.
I'm Drew McNutt with the law firm of Hollis, Wright. We often get asked what happens if someone is injured by a motorist who doesn't have any insurance coverage. In tonight's Legal 411, we will address uninsured motorist coverage. Under Alabama law, all automobile policies issued must provide uninsured motorist coverage unless the name insured rejects the coverage in writing. If you purchase this coverage and you are injured by an uninsured driver, you can make a claim against your own insurance company to compensate you for the injuries caused by an uninsured or underinsured driver. While liability insurance is required by state law, it is estimated that over 20% of the motorists in Alabama do not have any coverage at all. Uninsured motorist coverage provides you with the ability to protect yourself and your family in the event you are injured or killed by one of these uninsured drivers. If you are concerned about whether you're covered, I recommend that you check your declarations page or contact your insurance agent to discuss your coverage options. If you do not have uninsured motorist coverage, consider adding it. And if you do have it, discuss increasing your limits. Oftentimes, you can purchase hundreds of thousands in coverage for less than $100 a year. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on the real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WVTM 13.
Welcome back into the attorneys. About 8 minutes remaining in the show. So if you want to speak with the attorneys from Hollis Wright who are standing by live, you got a few minutes to do so. 844-LAW-TALK or locally in Birmingham, 205-324-3600. Or if you prefer to text, that number is 205-670-1949. So before we went to break, Carter, talking about the steps to take if you've been involved or injured in an industrial accident. Pick it up from there.
So the main thing an employee needs to do if they're injured in any type of work-related accident, whether it be an industrial accident or otherwise, is notify your employer that you were injured on the job, and you need to ask to go see the company doctor. That is sort of the starting off point. Now, that's if it's a non-emergency situation. Obviously, if you're injured catastrophically in an accident, you're taken by ambulance to UAB hospital or some hospital, then that's automatically going to be covered by workers' compensation. But in a general sense, if you injure your back or you've got a non-emergency type injury, you need to make sure your employer knows about the injury, because there are time components to that, and if you don't comply with the time limitations involving notification to the employer, it can give them a defense to a workers' comp claim to where they might try and avoid paying you for your time off of work as well as paying your medical benefits. So that's probably first and foremost. Also, if you have the ability to take photographs that you think might be important depending upon the type of situation that you're in. If there are witnesses to the accident and you're not injured emergently and you have the ability to find out who the witnesses are, that's important. To any type of investigation gathering of that kind of information can be very helpful.
What about workers' comp?
Well, so remember the launching off point, I said there are really kind of two avenues or two claims that you could potentially make in these types of situations. One is your workers' comp claim, and the other one would be a claim against a co-employee or a third party like a product manufacturer. So those are sort of the two directions you can take this. Workers' comp is what I would characterize as a more of a short-term or immediate avenue that you need to take, because obviously if you're injured and you're off work, then you need to notify your employer and you need to ask them to start what are called temporary total disability benefits. They're TTD benefits, and that can actually give you some compensation while you're off work. And then the other aspect of that is getting your medical bills paid. Workers' compensation should be responsible and is responsible by law for paying for your medical bills. And so those are the two things that you need to do immediately and get that on track. And then ultimately, if you have a permanent type injury, not able to go back to work, or you're able to go back to work but in a limited or a reduced capacity, you might have a permanent claim that will allow you to get some additional benefits for that permanent type injury.
Let me tell you a scenario that is true. A friend of mine who his father came here from Venezuela or something, does not speak the greatest English, had a job at a manufacturing plant, got a back injury due to an issue at the plant. He did not know it at the time, but he would never work again. But the company offered him a settlement, more money than he had ever seen in his life. But now he can no longer work, and that amount of settlement has not lasted. And so now he's he's in a pickle. He signed something, he signed it away, he accepted the settlement. To me, that's sad, because now they've got to figure out how to make it work. But he never consulted an attorney. Do you see that?
Yeah, and that's a great cautionary tale that we see from time to time, and that's a big mistake that employees make, to not immediately contact an attorney, because remember, under Alabama law, and it's a little bit different than most states, but under Alabama law, the employer, and when we talk about the employer, really what we're talking about is the workers' compensation insurance company, but they are liable or responsible for lifetime medical benefits for that individual. So if you've got a back injury, it's likely going to stay with you for the rest of your life. And if you're 40 years old and you're looking at a life expectancy of another 30 or 40 years, well, guess what? The workers' compensation insurance company, they want to get you off their books.
Right.
They want to settle the claim with you for as little as they can settle with you for. And oftentimes what they'll do is they will offer what most would consider to be meaningful money, but as part of that offer, they are going to ask you to settle your future medical benefits, okay? And once you do that, once you sign that release and settlement agreement, you're no longer going to get those future medical benefits because you, quote, settled your future medicals. And that happens from time to time. Now, one of the good things about workers' comp, though, is that these settlements have to be approved by a judge.
Okay.
So if you have an individual who does not have a lawyer and they are to settle the claim in circumstances where they really should not be settling, they do have to some extent a backstop, and the backstop is the judge. The judge is supposed to evaluate it and make a determination as to whether the settlement is in the best interest of the individual who was injured. Sometimes they may not do that necessarily, but sometimes they'll look at it and say, this is not in your best interest, you need to go see an attorney. But definitely would encourage people to consult with an attorney.
Yeah. A couple minutes remaining. Before we get to your final thought,
Yep.
is that the most common mistake you see from people with these kinds of cases?
Yeah, a delay in getting to a lawyer in a workers' compensation type setting would probably be one of the biggest, and then also failure to notify or report the incident to an employer in a timely manner and consistent with the time restraints that Alabama law has in place.
Yeah, and that's the thing, even in this instance, he had no idea he would never
That's
work
right.
again, but if he had legal counsel, that's the kind of advice, somebody that can help you worst case scenario.
That's right, and I don't know what his settlement was for, but I mean, it may be likely so that a lawyer could have gotten him a whole lot more, and especially in a back injury, because oftentimes people hurt their back and they try and just live with it, and then they wind up having a surgery and it makes it even worse, which all of that enhances the value of your claim.
Yeah. All right, we have right at a minute remaining. Anything from you? What do you want to leave our viewers with?
Yeah, I think kind of the final plug I would leave the viewers with, and we haven't talked about this, is if you are an employee in a job that is presenting dangers or hazards, whether it be in an industrial setting, a commercial construction setting, a residential setting of some kind involving hard manual labor, make sure you get properly trained. Make sure you're asking your employer to provide you with the necessary personal protective equipment that you need in order to be able to successfully and safely do your job, and err on the side of asking questions. Mm-hmm. Questions are very important. Ask to get clarification, ask to get that type of safety equipment. We see a lot of mistakes in that regard where people are not properly trained, and they could have done more to get properly trained.
And if you've got any questions on this, 844 Law Talk, Hollis Wright is a great firm. If you've got questions, wondering if you've got a case, great folks just to see answer any of your questions. Carter, appreciate your time as always, and we always appreciate you being with us as well. Thanks so much. We'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.